Chief Justice, good morning, members of the board panel. I'd like to also congratulate Judge Wagner. I know it's been several months, but haven't seen you. Adam Namias of the West Tennessee Bar. Brian Williams of the Ackerman firm will be arguing on behalf of the Appellant Berkeley Research. Thank you.
Thank you.
Good morning, Your Honors, and may it please the Court. My name is Ryan Williams. I am here on behalf of Appellant Berkeley Research Group. And for Your Honor's edification, I have reserved 7 minutes for rebuttal. I first and foremost, Your Honors, would like to thank you all for your time. I know there's been extensive briefing in this that you've needed to read, and I appreciate your time this morning. I also want to extend my deepest gratitude for allowing me to come to this beautiful state of Tennessee and indulging me in front of you, allowing me to make these arguments. So thank you. Your Honors, we stand here today on the cusp of what could be extremely dangerous precedent if this court were to interpret Section 327B of the Tennessee Uniform Arbitration Act as the exclusive or sole basis for subject matter jurisdiction in order to confirm an arbitration award in Tennessee. And when I say that, Your Honors, it's not rhetoric, it's not hyperbole. It is the exact circumstance that is faced here by BRG. And at best, under a best case scenario, what this interpretation would result in is a situation where the legislation and the court would be invalidating a term entered into by private parties into a private arbitration agreement, i.e. where a confirmation award can be confirmed. It would result in a process that is inefficient, expensive, would require multi-state jurisdiction where the same issues could be raised in front of multiple courts, and that's the best case scenario.
Well, Mr. Williams, respectfully, we have to deal with cases that have serious ramifications day in and day out, so we recognize that. So let's get to the actual argument, please.
Absolutely. Worst case scenario, Your Honors, is that this admittedly valid arbitration award would be rendered a nullity and of no effect. And so let's look at exactly why and I will refer to this as a restrictive reading if it's only 327B that confers subject matter jurisdiction. But let's look at why this would be the case. So there's a commonplace scenario.
Sorry, before you launch into that, I do want to clarify which statute actually applies here. We have the Uniform Arbitration Act that was enacted in 1983, and then we have a revised Uniform Arbitration Act that was enacted in 2023. I think the briefing focuses mostly, if not exclusively, on the revised Uniform Arbitration Act, but is that, given the timeline of everything that occurred here, is that actually the applicable statute?
Well, so Judge, I think that there is a question as to whether it is the old version of the Act that applies or the new version of the Act that applies. We focus on the new version of the Act in light of the express question asked by the court referencing the new version, and we wanted to be responsive.
What's your position on which statute applies, though?
I would say that my position is that it is not necessarily clear which version applies, but what I'll tell you is this. The two pertinent sections of either the old version of the Tennessee Uniform Arbitration Act or the new version. When I say the two pertinent sections, I'm referring to, under the new version, Section 323 and Section 327B. Under the old version, 302 and 312. Those sections, candidly, Your Honor, they're not appreciably different.
Well, there are some textual differences, though.
There is, in terms of the exclusive language was added to Section 327B, saying exclusive jurisdiction.
So just going back to so you said that you're not sure which statute applies. Do you want to at least kind of provide us with your best guess as to which statute applies and what the salient factors are that we would need to consider in determining?
Well, typically speaking, statutes don't apply retroactively unless so stated in the statute. I believe that this confirmation proceeding was filed after, or was filed prior to the new version coming into effect. So if I had to opine on that, and this is a question we haven't closely looked at, frankly, Your Honor, but I would opine that it is the old version of the Tennessee Uniform Arbitration Act that applies.
And that's because?
That's because the act the new version of the act was ultimately put into place or accepted in 2023.
So the old version was in effect when the arbitration agreement was entered?
That's correct.
But the new version was in effect when the confirmation proceeding was
Nope,
initiated?
The old version was still in
effect.
The confirmation proceeding was filed.
Okay.
So, and honestly, so if we're going to talk about which version of the act applies, I think honestly, the old version of the Tennessee Uniform Arbitration Act actually makes it such that this case is very simple for the court. And I'll tell you exactly why. Under the new version of the TUAA, there was a new provision added. That section.
Counsel, before you continue, you may want to shift over to the microphone
My
just so
apologies.
that,
My apologies.
yeah, the live stream will pick up your argument.
Very good. Thank you, Your Honor.
You're welcome.
So under the new version of the act, Your Honor, there was a new section that was added. And that section is 305C. Now 305. Section 305 is critical because what Section 305 says is, number one, in the context of Section 327B or 327A for that matter, it can only be waived after there's a dispute arises that is subject to an arbitration agreement. So we have this waiver provision. Section 327B can be waived, but only after a dispute has arisen, subject to an arbitration agreement. Section 305C, under the new version of the Act, says Section 323, the section that we contend and that the appellate court contends afforded jurisdiction here, can never be waived. Can't be modified, can't be waived. So we have this new section under the old Act that says these provisions, 327, 323, 327 can be waived in some instances, 323 never waived. Okay. Now, under the old version of the Tennessee Uniform Arbitration Act, these waiver provisions don't exist. So what does that mean as a practical matter? Well, we go right to the contract. We go right to what the parties agreed to. And those sections can be waived under the old version of the Act. So if we're talking about the old version applying, I find this case to be quite simple, candidly, because ultimately we have a contract that says this award, an arbitration award, can be confirmed in any state. We have JAMS rules to which all parties agreed. That's the judicial arbitration mediation services. We have JAMS rules that say the award shall be confirmed in any state or federal court. And so, given the waivability of these sections under the old version of the Act, it's very simple.
Well, it says any state in which there's jurisdiction, though. How does that temper interpretation?
So honestly, the way that I view that, Your Honor, so true, that may refer to subject matter jurisdiction. It doesn't specify. But the way that I see that provision, jurisdiction thereof, is that it really goes to personal jurisdiction. And ultimately, what that language means is
it says jurisdiction, right?
That's right. But parties cannot consent that a court has jurisdiction, right? So that a court has subject matter jurisdiction. That's within the court's purview, or it's the Constitution or statute's purview. So the way that I read that section is that what it really is a waiver of raising personal jurisdiction issues. What it is they're saying this can be entered in any state, and we are waiving personal jurisdiction issues.
So where do you, I think you just said parties can't confer subject matter jurisdiction.
Correct.
Where do we find subject matter jurisdiction?
Well, so Under the, under both the old version of the act and the new version of the act, it really comes from the confirmation portion, where the confirmation portion, which is 323 under the new version, that section very clearly states, so let me just be clear here, it's 323 under the new version and 312 under the old version. And that section is the section that the appellate court found conferred subject matter jurisdiction. So that section says that upon petition, a court shall confirm an arbitration award unless it has been, unless it's been set aside for other reasons referenced in the act. So that provision does not give any limitations as to where the arbitration was to occur, where the parties agreed for the arbitration to occur, and ultimately it's our contention that it is that provision, the section 323 of the new version of the TUAA, that confers subject matter jurisdiction.
If 312 is talking about subject matter jurisdiction, then what is 302B talking about?
So 302B under the old version of the act, 327B under the new version of the act, it is talking about, well, look, I think it's twofold, Judge, because if you go and read the RUAA, which is the Revised Uniform Arbitration Act, if you go and read the comments to the RUAA, they are very enlightening in terms of what that section means and what its purpose is. And so what it talks about initially is it talks about validity. Only this state or this court has exclusive jurisdiction to determine the validity of an award. That's what the comments to the RAAs or to the RUAA say, and I'm happy to direct your honors to that section. It's section 26 of the RUAA, and it is comment 1. But I think more important, and so also, this makes sense that this is a validity issue, because what you don't want to happen here is that courts or that parties who have agreements that are silent as to where an award may be confirmed. What you don't want to happen is that a party runs off to some foreign jurisdiction that they perceive as being favorable to them. Maybe it's their home jurisdiction, maybe there's better law with respect to the issues that they're raising. You don't want them running off to a foreign jurisdiction in order to challenge validity of the opinion, as opposed to confirmation, which is really a ministerial task. The other thing, and I will say this to you, so I practice a lot of, I do a lot of LLC member disputes, fortunately or maybe unfortunately. But ultimately, the way that I read this provision is this: the parties have the right to contract. And like these Uniform LLC Acts, the Uniform LLC Act applies unless the parties have addressed the issue in their contract, in which case the contract applies. So the way that I read this is that the TUAA supplants. If the agreement is silent as to where an arbitration award may be confirmed, well then fine. The fallback is 327B or 302, as your Honor astutely noted. However, if there's jurisdiction under Section 323 as well, then parties are free to say, we will determine where we are free to contract and determine where an arbitration award is to be confirmed. The other thing that I would like to note while we're talking about why we believe that Section 323 or old Section 312 confirms or provides jurisdiction is it comes from, again, the comments to the Revised Uniform Arbitration Act. And where I would direct your attention there is Section 22 of the RUAA. So Section 22 is the equivalent of the current Section 323 under the TUAA. Comment 1 in that section states, the language in Section 22, TUAA Section 323, has been changed to be similar to that in Federal Arbitration Act, Section 9, to indicate that a court has jurisdiction at the time the party files a motion. So we see right here in the comments to the revised Uniform Arbitration Act that the drafting committee is referencing jurisdiction in the context of Section 22 of the RUAA and in turn, Section 323 of the TUAA. The final point that I would like to make about this particular issue, Your Honors, is this. There is a lot of, there were many statements included in the Attorney General's brief talking about Section 323 or its equivalent under the RUAA, Section 26. But when we go and actually look at what those comments say and what the actual drafting committee's comments say, and when we go and actually look at what the cases say, they actually support the notion, the exact notion that we're advocating here, which is this: parties to private arbitration agreements should be entitled to freely determine where their arbitration award is going to be confirmed. They should be entitled to select a state. And there's good reason for that, because with these arbitration agreements, we commonly find ourselves in situations, as is the case here. We have BRG, well, they're a Delaware entity. We have Southern, we contend that they're a Tennessee entity. They say they're a Delaware entity. We have underlying litigation in New York. We have experts in New York. And we have an arbitration hearing that was to occur in Pennsylvania. And so parties routinely select an arbitrary state, a state that is neutral for purposes of fairness, for purposes of convenience, for purposes of just geographical location. Let's pick somewhere where neither of us have connections. And so under that circumstance, which is a very common circumstance, it presents a situation where if we say, well, only the state where the parties agreed to arbitrate, that is the only state where this award can be confirmed, you can bet that, as was the case here, the very first argument that the defendant is going to raise is, sorry, you don't have personal jurisdiction over me in this state. We don't have any presence here. We don't do business here. This state was merely picked as a neutral location for purposes of convenience. You have no personal jurisdiction. It candidly, this issue of personal jurisdiction, it has made it all the way up to the highest court in Tennessee in terms of whether there's personal jurisdiction over Southern in this issue. So, in this case. And so that is the reason why it simply wouldn't make sense for 327B to be the sole portion that confers jurisdiction, because ultimately parties can render, using procedural gamesmanship, they can render an arbitration award a nullity. And they can make it such that that arbitration award can never be enforced. And that is not only directly contrary to the express policies behind the Tennessee Uniform Arbitration Act, but also the Federal Arbitration Act.
Counsel, can you point to any authority in any jurisdiction that has adopted the interpretation that you are advancing now?
The authority, the sole authority that I can point to is the authority that the appellate court, in the appellate court decision, where they referenced 323 as providing a basis for jurisdiction. But I think ultimately here, a close reading of the various cases, of the various RUA drafting committee comments, as presented by the Attorney General, I think that ultimately those cases, when closely read, make the exact point that BRG is advocating here. And let me give you an example. So I'd referenced Section 26 of the RUAA, and it is comment 3. This would be, 326 would be the present RUAA Section 26 would be the present TUAA Section 327, okay? So here's what the drafting committee says about it. the rationale of these courts, and these are courts that are, making a determination as to exclusive jurisdiction, right, saying it's in our state. The rationale of these courts is to prevent forum shopping and confirmation proceedings and to allow parties autonomy in the choice of the location of the arbitration and its subsequent confirmation. So the drafting committee notes focus on the concept of parties should have autonomy to select where their arbitration awards.
Well, but doesn't it presuppose that the subsequent proceedings to enforce the arbitration will be in the same place as where the arbitration occurs?
Not necessarily, because ultimately there needs to be a distinction between where the arbitration occurs and where the award shall be confirmed. And this goes back to the concept of, if we're in a neutral location and that is the sole location that can confirm the award, well, you need subject matter jurisdiction and you need personal jurisdiction. And so ultimately, that would render the award a nullity if the party was successful in this personal jurisdiction argument. So what this says is that parties should be allowed autonomy in the choice of the location of the arbitration and its subsequent confirmation proceedings.
So where did this arbitration occur?
Well, it's difficult to say because it ultimately occurred via Zoom, Your Honor.
That's why I was asking, did it occur nowhere? Did it occur everywhere? How do we?
It is an interesting question, Your Honor. It occurred somewhere in the cloud.
Is it
floating across the
legally
United
relevant
States.
to the determination of this case?
Well, so ultimately, I would say that it is not, Your Honor, because I think that if 323 is read to confer subject matter jurisdiction upon the court, then it really is irrelevant where the arbitration hearing was to occur.
I mean, certainly the contract indicates where it was anticipated that it would
That's
occur,
correct.
but by agreement,
Correct.
it did not.
That's correct. There was a subsequent, due to COVID, there was a subsequent agreement whereby the arbitration occurred via Zoom. And the arbitrator in his award indicates that he was in Pennsylvania. The parties, candidly, Your Honor, I'm not certain where the parties were located. But I mean, ultimately, they're all in front of a camera. And this arbitration is occurring in the cloud, if you will. I mean, it's across the United States. To your point, it's everywhere and it's nowhere. But the other point that I just want to make about this comment 3 to the revised Uniform Arbitration Act 26 is that there's a case upon which the Attorney General relies heavily. It's the State Ex Rel Tri-County Construction Co. versus Marsh. And in that case, there is an enlightening quote, which says this: modern business operates in a multi-state environment, and the parties should be permitted to choose the place of arbitration and confirmation upon consideration of convenience. And so ultimately, all of these various cases, they all look at the concept of arbitration agreements are freely entered into by private parties. They are entitled to select their terms, and ultimately, for purposes of convenience, for streamlined proceedings, the parties are able to determine where that arbitration award should be confirmed.
But doesn't that by definition mean that it needs to be put in the contract?
I'm sorry.
Well, I mean, if the parties are going to agree to where the confirmation can take place, doesn't that contemplate that part of the agreement contains not only where the arbitration would take place, but also where the confirmation would take place?
Well, I think that agreement does just this. It does just what you're describing, Your Honor. And my authority for that is the Third Circuit case from the generational equity case, where the court said, interpreting a provision just like the provision that we have, except under the AAA rules, the court said, well, these parties, or the losing party, because ultimately it deals with confirmation of an award, have agreed to any state to any state in order to confirm the arbitration award. So this concept that the parties can freely contract, and it is that, Judge, because ultimately, at the end of the day, what is the focal point of a confirmation proceeding? What is the purpose of it? And the purpose of it is to allow that arbitration award to be collectible, to be enforceable. And so filing somewhere, saying, hey, we're entitled to file wherever, and then ultimately filing where admittedly there are collectible assets, where there's an office, where there's a registered agent that was served, filing in that location, it makes a great deal of sense. Here's why. 2, the process, so the Attorney General cites to the Pennsylvania Arbitration Act, and they say Pennsylvania has exclusive jurisdiction because the arbitration agreement said arbitration was to occur in Pennsylvania. Okay. Now, Southern says, nope, the only place that this can be done is Delaware. So, if we were to take this procedural step first of filing in this neutral location, Pennsylvania, you can bet that the first thing we're going to get is a challenge to personal jurisdiction. Let's say we win that challenge. And look, that's a maybe so, maybe not proposition. But let's say we win that challenge. And let's say that the court says, you know what? There's personal jurisdiction in Pennsylvania to confirm this award. Well, now we got to jump through another procedural hoop and go back to Tennessee. And we go to Tennessee and we say, hey, please enter judgment or register this judgment so that we can collect on it. Well, Tennessee does not afford full faith and credit to judgments that are entered without personal jurisdiction. So now we find ourselves in a position where we are litigating the issue first in Pennsylvania. If we win, maybe so, maybe not, then we go back to Tennessee. We're now in Tennessee. And Tennessee says, okay, well, we'll afford this judgment full faith and credit if you can show personal jurisdiction. They're entitled to raise that issue again in Tennessee. So now we're litigating twice in 2 separate forums the question of the losing parties the losing party's personal jurisdiction in Pennsylvania. This is a process that is incredibly inefficient, ineffective. It's not business friendly. It is expensive. It requires attorney's fees. It requires multi-state jurisdiction, when the entire concept behind arbitration and the confirmation of awards, this is from the FAA as well, Section 9, which we contend, if this statute were interpreted, would be preempted, interpreted in a limited manner, would be preempted by the FAA. Because
the FAA does not apply to this case.
So, Your Honor, I must respectfully disagree, and I'll tell you why. So first and foremost, under the JAMS rules to which all parties agreed, the JAMS rules expressly provide, and I see my time is up, but I will keep going.
Let you, and how much time did you reserve?
7 minutes.
All right, you can encroach on that as needed.
Thank you, Your Honor. So here's why I must respectfully disagree. Number one, the parties agreed to the JAMS rules. And the JAMS rules say the confirmation of an award, reducing it to a judgment, is subject to the Federal Arbitration Act. That's number one. Number two, ultimately, if the matter involves interstate commerce, it is most certainly subject to the Federal Arbitration Act. So we have agreement in the first instance, and we have a matter where we've got experts in New York. We've got an underlying case in New York. We've got a party that claims they're in Delaware. We say they're in Tennessee. We've got a arbitration provision that says the arbitration needs to occur in Pennsylvania. So ultimately, this absolutely involves interstate commerce, making the FAA applicable. But there is one, and we have done extensive research.
But the FAA doesn't address the location of does it?
Here's what the
Am I
FAA
misunderstanding?
So here's what the FAA says, and in particular, Section 9. It says that parties can freely contract to where an award will be confirmed.
Okay.
So there's literally one case on this that we've been able to locate that deals with this exact issue, and it is that generational equity case. It is a case that was decided by the Third Circuit. And what that case says is there's a Pennsylvania law That law says if you're an unregistered foreign business, you can't use Pennsylvania courts for any purpose, okay? The parties had the exact same agreement that we have with respect to arbitration award can be confirmed anywhere. And what the Third Circuit said was this Pennsylvania law runs directly contrary to Section 9, runs directly contrary to Sections 2, 3, 4 of the FAA because it serves as a blockade to confirming an arbitration award, and they found that the FAA preempted this Tennessee state law, this Pennsylvania state law. The other critical thing that I just want to say about this decision too is that the Pennsylvania state law brought into question whether the court had subject matter jurisdiction. Because ultimately because of this law, there was an argument, there's no subject matter jurisdiction because this law says you can't use our courts for any purpose. Okay. And what the Third Circuit said is your law is preempted.
All right.
And so with that, I will...
you can reserve the remainder.
Thank you. I will reserve the remainder. Thank you.
Good morning. Philip B. Seaton on behalf of Southern Advanced Materials.
How is your time going to be allocated?
I was going to give my friend over there additional 5 minutes. He's the Attorney General handling the issue.
Okay,
Their
so
amicus brief.
your time would be?
20 minutes.
20 minutes, all right. Gotcha.
May I talk about facts? There's a lot of interesting concepts we've just heard articulated, a lot of hypotheticals, a lot of maybes. But the facts are, this was just a simple contract executed between two parties. There was no long-standing relationship either before or after. Berkeley Research Group was to provide an expert to validate a valuation for the damages sought against Robert Abrams by Southern Advanced Material, LLC, Delaware. The Delaware Corporation was the only corporation which was involved in that litigation, and as with this particular corporation, BRG, they're both Delaware LLCs. Consequently, when the documents were drafted, the documents indicated that the laws of Delaware would be interpreted and controlled by Delaware. So you had not only interpret, but also control. Now, that may be splitting hairs, but I think it's relevant in this case, meaning that you follow the Delaware procedure. The Delaware has a very specific procedure about how you docket arbitration awards. It's found, it's Title 10, Sections 57. You've seen it in our paperwork. When you get an award in Delaware, you take that award, you take it to the court certifies that award, and I can give you the sections if you want them. And then with the certified award, you go out and you can file that judgment in any state that permits it, just like it was any contract case. They didn't do that. They didn't do that.
Can I ask a quick clarification question? Am I right that there is now a pending proceeding in Delaware to enforce? Okay.
Yes.
Go ahead.
So having dropped the ball, because the only requirement of Delaware to getting your arbitration awards, I'll say certified, is that it has to be done within 1 year of the actual entry of the order, which we have in the arbitrator's order. They haven't done that. So now they're back they're in court. The first, and it's exhibits 2 and 3 of our papers, the first time they did it was amazing because they went back to the Delaware court and said basically, they were starting to say, can we re-energize this proceeding, which the answer to it is no. Then they amended it to try to go to the Federal Arbitration Act, which is still pending. So these two matters are still pending in the courts in Delaware.
But those were filed, sorry, just to clarify, those were filed after the
After the failure.
dismissal by the Court of Appeals here?
Yes.
Or were the, okay.
Yeah, yeah. They were filed after the award that was, the Court of Appeals award dismissing jurisdiction. And so what we're faced with today that you have to determine is to whether or not the requirements, strike that, whether the award given by the panel here in the appellate division should be affirmed or denied. There's really nothing else, I think, that's an issue, but you may have a question.
I'll ask you the same question I asked opposing counsel, which is which statute governs the arbitration agreement here? Is it the old statute or the new statute?
I don't really know the difference between the two, honestly. I'm just going on what the facts on the ground tell us. There has been an arbitration proceeding, and an arbitration proceeding my adversary didn't follow the procedure that when they won the award, and now they're groping to see what they can do. And I don't think there's any more to what I've just said than that.
You don't have an opinion about what statute
Pardon
we're
me?
applying? Did I hear that correctly?
I mean, which statute are you relying on for your argument that there was no jurisdiction here? That there's no subject, the revised statute?
No, I'm referring to Delaware Code Title 10.
Well,
In other words, this is all governed by Delaware. Tennessee has nothing to do with this case. Nothing. This is a Delaware case. The arbitration is a Delaware.
okay, how about the uniform, all right, so what, go ahead. That's fine.
I'm sorry, ma'am.
No, that's okay, go ahead.
No, our position is basically Judge Stafford and his panel got it right. There is no jurisdiction. And what I'm saying to the court is now BRG is thrashing around trying to find alternatives to what has already been determined. My position is there is no jurisdiction.
So is your position that that the Tennessee courts did have subject matter jurisdiction but not personal jurisdiction, which is what the COA held?
Judge Stafford ruled they had neither subject matter jurisdiction or personal jurisdiction.
Actually, respectfully, Your Honor,
No.
your counsel, that's not correct.
No, that's not
They
correct.
found that there was subject matter jurisdiction. They did it in a footnote, but they said there was subject matter jurisdiction.
And the basis of the ruling was personal jurisdiction.
Correct. That's correct, Your Honor. Personal jurisdiction.
So do you have an opinion on the subject matter jurisdiction issue?
I think what the amicus brief we filed would be the opinion I would adopt. I think that's for the court to determine. That's really above my pay grade.
Okay.
So if you have any other questions, I think I've explained our position as clearly as I can.
All right.
I thank the court.
Thank you, counsel.
Good morning, and may it please, or I guess good afternoon at this point, and may it please the court. My name is Harrison Kilgore, and I'm with the Tennessee Attorney General's Office. I appreciate the opportunity to appear as an amicus here today. Subject matter jurisdiction goes to a court's fundamental authority to adjudicate a matter, and it must be conferred on a court by constitutional or legislative act. Here, we all agree that the relevant source of jurisdiction is Tennessee's Arbitration Act. Under the plain language of that statute, the Chancery Court here lacked subject matter jurisdiction to enter judgment on Berkeley's award because the arbitration agreement between Berkeley and Southern specified arbitration should occur outside the state of Tennessee. I'd like to turn initially to Berkeley's argument that Section 323, I guess maybe first, Justice Campbell, I should address the question that you've posed to both of my co-arguers as to which statute applies. The state has taken the position, and I think at this point, my friend on the other side has agreed that the prior statute applies because that was the statute that was in place not only at the time that the contract was entered into, but also at the time that this confirmation proceeding was put into place. And that was also the approach that was adopted by the Tennessee Court of Appeals in Collier Engineering. To the extent that the court has any further inquiry on that, I would point you to section 29.5.304, which discusses the applicability of the revised statute. Section 323 does not confer jurisdiction. It is simply not a jurisdictional provision. Instead, what that does is it creates a right of action for those who are successful at arbitration to come into court and seek confirmation of their award, and it instructs courts how they are to proceed once that occurs. I would direct the court to the Kahn case, which is at 584 Southwest 3rd, Penn site 426, as well as 429 to 431. And in that case, the court recognizes this distinction specifically as to 302, the former jurisdictional provision, and 312, the former confirmation provision, where it recognizes that 312 discusses the proceedings and 302 discusses jurisdiction. It draws that distinction. And I would also point the court to Hogan, in which case the court evaluated both 302 and 312 and upon determining that 302 did not confer jurisdiction on the court, later decided that there was no other basis of jurisdiction, so implicitly finding that 312 was not a jurisdictional provision. And then finally, I would point the court to Teltec, which is a decision out of the Missouri Court of Appeals, and that's at Penn site 442 to 443. In that case, that we were not dealing with the confirmation of award, but of an arbitration award, but rather a motion to compel. But even in that case, the court recognized that there were separate provisions that provided for compelling or procedures to compel that were separate and distinct from the jurisdictional question. And the court said that even though the UAA has provisions specifically authorizing courts to compel arbitration, a court still must have jurisdiction over the arbitration matter. And in that instance, cited to the former 302 language. I think not only that, but Section 327, I guess I should say, the jurisdictional provision specifically discusses jurisdiction. It's labeled a jurisdictional provision, versus 323 makes no mention of jurisdiction. Typically, when you're evaluating the statutes, the specific controls over the general, as well as the fact that my friend on the other side has pointed to the comment, and that is raised in the RUAA Section 22, Comment 1, which seems to indicate that jurisdiction may be conferred. But I would note that the comment itself says that the provision was amended to indicate jurisdiction and not to confer jurisdiction, and that it's also said that it was meant to align the language with Section 9 of the Federal Arbitration Act. But I would point you to Section 9, which is a little bit more robust than, it's certainly structured differently than how the Tennessee Act is structured. So Section 9 addresses awards, confirmation, jurisdiction, and procedure. And what the Tennessee Code does is it separates those out. So to the extent that it's aligning with Section 9, it's aligning with Section 9's language relative to awards and confirmation, but not necessarily jurisdiction, which has been broken off separately into the jurisdictional provision of Tennessee's Arbitration Act.
There was an allegation of preemption under the FAA?
I don't believe that the FAA actually applies in this case. I would first of all note that, I guess first I would say that the only statute that has been invoked for jurisdiction, if you go to Volume 1, Page 1 of the record, that's the petition that was filed, was the Tennessee Arbitration Act. I know that my friend on the other side has suggested that because the JAMS rules apply, the FAA also applies. But the JAMS rules say that the FAA or applicable state law shall govern. And in this case, they've invoked the applicable state law of the Tennessee Arbitration Act. And then finally, preemption does not apply here simply because, first of all, there's no conflict between the Tennessee Act and Section 9. So the relevant language of Section 9 is, if no court is specified in the agreement of the parties, then such application shall be made in the United States court in and for the district within which such award was made. Obviously, the Chancery Court is not a United States court, and it's not within the district that it was made. I think instead, to the extent that preemption has been raised, there's an argument that this would frustrate the ability to enter judgment. And I respectfully disagree with that. I think that if my friend on the other side had taken the judgment that they were awarded and walked across the street in Pennsylvania to have it confirmed, it would be confirmed, reduced to judgment, and then under the uniform, this is a mouthful, but the Uniform Enforcement of Foreign Judgment Act, he could bring it back to Tennessee and have it domesticated here in Tennessee. And then to the extent that Southern, I know that there's disputes about this, but to the extent that Southern has assets in Tennessee, it could then attach that judgment to those assets.
Is it pertinent at all that the arbitration was virtual and not in any particular location?
Not for purposes of this case. I think because the language of the statute says that jurisdiction is confirmed upon the agreement of the parties to arbitrate in this state, and that did not happen here. The parties explicitly provided for arbitration elsewhere. And not only that, but there's nothing in the record to indicate that there's any tie to Tennessee that occurred. So I admittedly, I am sure COVID created all kinds of interesting law about personal jurisdiction over Zoom, but I think that there's no need to wade into it here because it just doesn't ultimately affect the outcome of this case and the lack of jurisdiction here.
Mr. Kilgore, let's look at Section 302 and the language at issue in subsection B, which says that the making of an agreement described in this section providing for arbitration in this state confers jurisdiction on the court and the rest of the statute. But the notable difference between that provision and the revised act is, of course, the absence of the word exclusive. Tell me why we should read this language to essentially mean exclusive jurisdiction, even though that language here is absent.
I think, because that's how courts of appeals in other states have interpreted it, to say that when a state is specified as the location for arbitration, that state has exclusive jurisdiction to enter judgment on the award.
But those interpretations were, I assume, after this statute was enacted, right? Or is your argument that this statute was intended to codify pre-existing case law that had interpreted jurisdiction to mean exclusive jurisdiction in this context?
Yeah, I apologize, I misunderstood your question. Yes, I think the addition of exclusive into the revised statute, it was meant to codify, and I would point your honor to both the comments to the RUAA as well as the admittedly a secondary source that was drafted by Dean Hines, who was the reporter for the RUAA committee, in which he recognized that the purpose of including the exclusive language in the revised statute was to codify all of these cases that we've cited that had made that conclusion in the past. And I think that leads to one of the...
But did that case law, did that case law that had interpreted that, did that exist at the time Tennessee adopted its original Uniform Act? So that we could look to, so that we could interpret the language here as kind of against that background principle that existed in the case law to inform our interpretation of confers jurisdiction. I believe
all the cases that I have found come after 1983, and so they would not have existed prior to Tennessee's adoption of the...
So is your argument really just one of workability, that we can't, the only way to kind of make these uniform acts all work together is to interpret jurisdiction here to mean exclusive jurisdiction?
Well, I don't think it's necessarily, I think the exclusive language ties into the comity concerns that we've raised and into the uniformity because Pennsylvania presumes that it has exclusive jurisdiction. But I think here, looking to the language of the old act, even removing exclusive, it's still the making of the agreement specifying for arbitration in this state that is providing and conferring the jurisdiction. So I don't think we have to worry as much about whether or not we can plug exclusive back into the UAA as much as what it may mean moving forward for other states who have adopted the RUAA in light of the interpretations of the UAA.
So I guess the argument then more is that this is the only source of jurisdiction
I think that's right. And
for Tennessee courts for subject matter jurisdiction. And since the agreement at issue here did not agree to arbitrate in Tennessee, there is simply no source of subject matter jurisdiction for us to confirm the award.
Right, that's exactly right. And my friends on the other side have now conceded that the State Arbitration Act is the sole source of jurisdiction. They say that there are different provisions that are jurisdictional provisions, but I think that everyone now agrees that the State Arbitration Act is the source of jurisdiction here. And so yes, we would say that by virtue of that, of the language that requires an agreement to arbitrate in the state to confer jurisdiction, by specifying a different state, they necessarily did not confer jurisdiction on Tennessee courts.
But would your argument be the same if, suppose we had two parties that did agree they agreed to arbitrate in Pennsylvania, but there was another provision of the agreement in which they agreed to confirm, to have confirmation proceedings in Tennessee. This earlier act applies. Would your position still be the same, that Tennessee courts would lack subject matter jurisdiction over that confirmation proceeding? I mean, that would require you to interpret jurisdiction in the older act to mean exclusive jurisdiction.
I do think that if in an instance where the agreement was to arbitrate in state X, but later to confirm in state Y, I think because the only means by which Tennessee courts obtain jurisdiction is through a legislative or constitutional act, then yes, I think the Tennessee court would not have jurisdiction in that case because they've specified a different location. And for that proposition, I would direct you to the Chicago South Shore case, in which you had two Indiana parties who entered into an arbitration agreement that said that they would arbitrate in Indiana. Out of convenience, they went to Chicago. They then filed kind of dueling actions, one in Illinois and one in Indiana, to determine after the award was rendered to enter judgment. Ultimately, the Illinois court found it did not have subject matter jurisdiction because the parties had agreed to arbitrate in Indiana. And Indiana found that it did have subject matter jurisdiction, notwithstanding the arbitration in Chicago, because again, the key is where the parties have agreed to arbitrate. Mm-hmm. And I think again...
And so it really it requires a coupling of the arbitration and the subsequent confirmation proceedings.
Exactly. And in that sense, I have to disagree with my friend on the other side that people aren't able to determine or contract for where they're going to enter into, have judgments entered into. They're able to do so by selecting in the arbitration agreement where they intend to arbitrate. My friend has raised several concerns about expensive litigation or how difficult it may be, and those are all things that could be taken into account during the contracting process as to whether convenience is more important to a party than ultimately how difficult it may be, or where they might have to go to confirm, or where there may or may not be assets. Those are all things that can be discussed and considered before the arbitration agreement is entered into. And so in that sense, the parties are in fact able to contract for where the award will be entered. I see I just have a little bit of time left. So I guess in light of that, given that I have so little time, I would just say that applying the plain statutory language and the case law interpreting it, the Chancery Court lacks subject matter jurisdiction because the parties agreed to arbitrate outside the state of Tennessee, and this court should affirm the dismissal for lack of jurisdiction. If there are any other questions, I'm now out of time, but I appreciate the time.
Thank you.
Thank you.
Thank you again, Your Honors.
Mr. Williams,
Yes.
tell us directly and concisely what confers subject matter jurisdiction on Tennessee courts in this case.
So I believe that there are two sections, and it would be the prior section of
sources.
sources. So two sources, I'm sorry.
Okay.
Two sources. Well, so look, 327B, the current 327B, yes, it confers jurisdiction, as does section 323. And the way that I would read this ultimately is if an agreement is silent as to where an award is to be confirmed or shall be confirmed, well, then we go to the fallback. And the fallback is 327B, which says exclusively in Tennessee. So I would contend both sections do. The other issue that I'll present is I disagree that there has been some concession, that there's another basis for jurisdiction here. Because ultimately, the confirmation of an arbitration award, it really is, I don't even know if I'd call it akin to, it is really equitable relief. And it feels like it directly falls within the Chancery Court's ultimate jurisdiction as well. And so I think, as we argued in our initial brief, that there is concurrent jurisdiction for the Chancery Court to enter, or that gives them jurisdiction for them to enter, confirm an arbitration award. If I may just briefly address some of the things that were stated. So with respect to the issue of personal jurisdiction, so number one, this Delaware proceeding was filed out of an abundance of caution. And it was filed after BRG lost the appeal because in an effort to preserve their rights, we weren't certain if this honorable court would hear us. And so it was filed out of an abundance of caution.
And what's the status of that proceeding?
They've moved to dismiss it, saying that it wasn't timely because it wasn't filed within a year. And so ultimately, their position is this arbitration award is a nullity.
And that motion to dismiss is pending?
It's pending.
Okay.
Okay. So first, just want to address that point. Secondarily, this concept that there's no personal jurisdiction in Tennessee, absent going first to Delaware, as Southern's counsel contends. So we go to Delaware, we confirm the award there. Then we find ourselves in collection proceedings on that award. Well, first we go and register, presupposing they don't raise challenges leading to extra expense, extra time, all of the various things that go completely against the concept of streamlined proceedings. But let's say that we ultimately get this judgment in Tennessee. Well, then we serve a citation to discover assets. Maybe they don't respond. Which court would litigate that issue? Which court would determine that issue? Tennessee courts. We find assets in Tennessee. And in this case, it's important to note, there are unquestionably assets in Tennessee. They actually, BRG's counsel actually obtained a turnover order for $31,000. It was in a bank account that they used to pay BRG for the various services provided in Tennessee. So they go file a motion for a turnover order. Where is that heard? It's heard in Tennessee. Property in Tennessee. They go put liens on the property. Maybe they go to enforce those liens. Maybe they contest the enforcement of those liens. Where are those arguments heard?
So,
Tennessee.
so let's go back to subject matter
Yes.
jurisdiction, because everything that you're describing could also be taken care of by registering a foreign judgment and then embarking on trying to find assets and so forth. So on subject matter jurisdiction, my understanding is that the premise was that the old statutes would apply. And so which one do you say would confer subject matter jurisdiction under the old statutes?
So I don't have it in front of me, but I believe that it's 312 of the old statute. It's the 323.
The analog to
That's right.
323.
That's right. And I would note that your honors have made a very valid point here, and that this new statute, that 327B under the new act, under the current version, it adds the word exclusive, right? And legislatures don't add words to statutes unless they are to be conferred some meaning, right? So I do think it critical, and that word exclusive was added. I would also go back to the concept of these various sections. 327 the current 327 under the old version of the act can be waived. And so therefore, it goes to the concept that Section 323 likewise confers jurisdiction, as was stated in the RUAA comments, where they specifically reference jurisdiction in the context of what is the current day 323.
All right.
And with that, I believe my time is up. I very much appreciate this spirited conversation.
Thank you.
Thank you.
To all counsel in this case. We appreciate it. It's very interesting. The case will be submitted. And Mr. Hibner?